Hello, I'm Stuart Clark.
And I'm Garrett, Horrocks.
And welcome to Holland Estates. You are listening to episode number 585. Hello, Garrett. I think this is our first time podcasting together, so it's very exciting to have you with me today to discuss a very important, burning, issue that is at the top of everyone's mind on the estates list right now, which is the procedural differences between actions and applications. Hold your,
It's going to be heavy.
Pause now. So this came to be, so I wrote a blog about this, a couple weeks ago probably now, and I stylized it as kind of a little mini rant. I can't take it anymore, kind of, angry at the world. And it was done in jest and tongue-in-cheek. But I think it's an important thing to kind of talk about and raise because, if you're involved at all in estate litigation, you encounter these kind of procedural issues between actions and applications that I think are somewhat unique to the estates litigation bar, only because we in the estates litigation have to start so many of our proceedings by application in accordance with the statutes, the rules, etc. And then we often seek to, for whether strategic reasons or otherwise, convert these things into actions, that we have this weird kind of Frankenstein hybrid, who knows what monster that sometimes proceeds before the court if you don't pay attention to it. So I think today's just a day to say, hey, here's the issue, here's some things to think about when you're kind of going through the application versus action world, and what can we do? So Garrett, over to you. So can you tell us a little bit about what is an application, what is an action?
So an application is commenced by believe it or not, a notice of application, which is supported by a supporting affidavit. So an affidavit is a sworn statement of evidence, of written evidence submitted by the affiant, or the person swearing the affidavit, which also encloses all the relevant, or typically all the relevant documentary evidence that a party wants to rely on, and that's in their possession. In terms of how an application kind of unfolds, parties who swear affidavits will be cross-examined on their affidavits. It's not the typical kind of courtroom scene where you have a witness in a witness box being kind of examined by two lawyers and the judge is observing. That's kind of the typical action. An application is strictly done by way of written evidence and transcript evidence. So parties are submitted through cross-examination on their affidavits. Transcripts are produced. The transcripts will be put before a judge at a hearing of the application, and that's sort of the bulk of the evidence that's relied on, aside from the additional third-party evidence potentially. An action, in comparison, is commenced by a statement of claim and responded to by a statement of defense. Those are referred to as pleadings. There's no evidence is led in statements of claim or statements of defense. They're strictly statements of fact, I guess you could describe, as some potentially statements of law, but there's no evidence that's led. All of the evidence in an action typically comes out by way of examination for discovery of the party. So it's not a cross-examination. It's an examination for discovery where the examining lawyer has typically like a much broader kind of fact-finding type of mandate. Is that a fair way of kind of characterizing it?
No, I think that's exactly it, right? So when you picture in your mind, hey, your favorite, court-based legal TV show or movie, what you're imagining is an action where someone is has a deposition happening, or someone's in the witness box saying you can't handle the truth and all this kind of stuff. That's an action. Mm-hmm. That's the more typical court proceeding that kind of goes with the court when you're suing someone. An application, as you said, it's all on a written record. So it's kind of, if you think about it, it's kind of boring, right? Everything is being written and vetted by lawyers. They're writing out your sworn statements for you. Say, yes, I swear that this is true. And then that's your evidence, and you're attaching a bunch of documents. And you can see why, strategically, you may want to move something from way of application into the realm of action. Because if you think you have a sympathetic witness, or if you think that the witness is going to be a horrible witness on the other side, you may want to take it out of the realm of everything being on a written record and have it actually be them in the witness box saying their piece, which is great and it makes sense. But when you convert something from an application into an action, sometimes you can confuse or conflate procedural steps along the way. And you talked about about the discovery process, which is just that. You sit there and you're supposed to hand over all relevant documents. You kind of go over them forever. Then you have examinations for discovery, and that process is a process that only exists in an action. So, for example, if you are starting an application, so application for dependent support, application to pass accounts, there is no discovery process. So if you're doing an order given direction setting out, hey, how is this process going to go before the court, there is no discoveries. There's no affidavit documents. There's no examination for discovery. So when you're kind of plotting out how you want this to go, you need to keep that in mind. Everything is being done by way of this regular affidavit evidence unless you convert it into an action.
Mm-hmm. So I think that goes goes back to kind of the fact-finding mandate. So on a cross-examination on an affidavit in an application, you're strictly limited to reviewing what's been produced in the written record. You don't have this kind of expansive ability to go beyond that, right? So typically what you're looking at is strictly within that written record, and affidavits can be they can be great, they can be terrible. So really, it depends on the quality of the affidavit that the party's being cross-examined on, and strategically that can be potentially beneficial to a party. That can also hinder a party if the affidavit that you put forth on behalf of your client isn't particularly strong. So there's strategic concerns there, whereas in an action and when there's in examinations for discovery, there are typically a ton of documents being produced in affidavits of documents, and those are all essentially fair game. So the process is much more expansive in that respect. And that can lead to different results strategically depending on, and that's something to consider going forward.
Mm-hmm. So here comes my little mini rant portion of the podcast, which is just so we talk about kind of these general processes, and they are distinct, separate processes, and you gotta stick to your lane kind of thing. Process before the court. So as a result, you need to be mindful of what the next step is when you're setting out your order given directions. So, for example, if you've started your claim by application, say it's an application for independent support, but you immediately want to convert it into an action because you think you have a sympathetic witness or whatever, there is no. So once you have the order given directions issued, it's okay, converted to an action. There's no more affidavit evidence that should be before the court. Yet, that being said, it's shocking how often I get asked by opposing counsel to give either there's something to responding materials. I'm giving air quotes here. Responding materials due within 60 days. And you go, well, what the heck does that mean? Because we've converted it into an action. I'm responding to you. There are no responding materials other than we're doing statement of claim, statement of defense kind of thing, because there should be no more affidavit evidence that I have to leave. Conversely, if we're keeping it in an application realm, people sometimes forget that there are no discoveries, and so the number of times I get asked, well, say application to pass accounts. We're setting out the process for an application to pass accounts, and they say, okay, well, parties to exchange affidavit documents within 60 days of mediation. And you go, and if you're not thinking, okay, sure, whatever. But then that process doesn't exist within the application to pass accounts process. You're including action steps in an application, and it basically is meaningless. Mm-hmm. So be mindful if you are converting something, or even if you're not converting something, just be mindful of what the steps are of the distinct separate action versus application, so that you're not conflating and moving processes around, because if you do, you end up with this weird Frankenstein monster where you have a whole bunch of affidavits that have been filed which technically are meaningless in action because the judge won't even ever look at them, and all you've done is theoretically create a sworn document against which your client can be impeached, because now you have them saying, here's my whole case, here's everything I'm going to say, sworn statement, I swear this to be true, penalty of perjury. And then you say, great, well, those are meaningless, dumpster. But the other side has them. So now when they're asking your client questions later on, either in discovery or actually in the witness box, they have a sworn statement of what your client says is true. And if they deviate from what's in there, you're causing yourself a world of hurt. Mm-hmm. So why do it?
So I guess in summary, think carefully about how you want to commence a proceeding. I mean, it's not unusual, certainly in the state litigation context, that well, obviously proceedings have to be commenced by way of an application, but they're later converted into an action for various reasons, depending on the issues to be tried, and if the parties anticipate that credibility of any witnesses or parties will be an issue, you may want to consider converting to an action. But I think it's clear that you can't put that genie back in the bottle, so to speak.
No, exactly. Yeah, and then I can go on and on at this for hours. There's strategic reasons of when or whether you do it, and even if you are going to do it, when you're going to convert it. My personal inclination is usually convert early, because like I said, you don't want to have all this other stuff out there which is now meaningless, which is going to come back to bite you in the butt later on. But sometimes you may not realize you want to convert something until you've gone through a couple steps. If that's the case, if you're kind of going down the application road and go, oh shoot, let's jump over to the action, you need to be mindful of the fact that the rules kind of dictate what you can and can't do. Like, for example, the discovery process and examination or cross-examination process for affidavit or action versus applications are governed separately and have very different rules. So for an application, for example, I think it's Rule 39.02 says that once you've cross-examined someone, you can't deliver new affidavit evidence without leave of the court. That doesn't exist in an action. So to the extent that you've decided if you want to cross-examine someone early and you're in an application realm, well, you may have shot yourself in the foot from filing new evidence, which may not exist in an action round. So maybe you want to convert it to an action so that you don't have to worry about that. There's a whole bunch of these things to consider. But yeah, I mean, as I said, something on paper, which is not the most exciting thing to think about. Law class 101, how do you sue someone? Action versus application. But it is shocking how often people may get confused in the processes. So don't be that person. You want to look like you know what you're talking about. And if you are clear and consistent in your realization and application, you know, not that application, but application of the differences between the two, you look like you know what you're doing.
Mm-hmm.
That's a good thing. So do it. I think that's, you know, my rant. As I said, it's half in jest because, you know, we've all been there, and I'm sure having put this now out into the universe, someone's going to email me saying, "Remember that time when you did that to me?" And I'll say, "Yeah, shoot, you caught me." Try to, you know, limit it, and it's a good thing to kind of keep, you know, top of mind.
Mm-hmm.
But yeah,
Agreed.
all right, rant done. So I think that concludes our podcast. So until next time, again, I want to thank you for listening. I'm Stuart Clark.
I'm Garrett Horrocks.
And should you have any questions, please email us at webmaster@hollandhall.com or leave us a comment on our blog. Thank you for listening.
Thank you.